I'm Arnold Loewy. I'm the George Killam Professor of Criminal Law at Texas Tech School of Law. My book is entitled Criminal Procedure, Cases, Materials, and Questions. The focus of the book obviously is on criminal procedure. It's designed to have the investigatory part taught in a 3-hour course, the investigatory and adjudicatory part taught in 4 hours. The places where it's different from most book is that it focuses the student's attention on questions and notes. They do have the opportunity to read the questions in advance, and these are things that can be focused on in class. My ordering of the material is somewhat different from other books. I postponed the exclusionary rule till the very end of the Fourth Amendment because I think the students should be aware of what it is that's being excluded before they start studying whether exclusion is a good idea or a bad idea. I begin with probable cause, what I consider the substantive heart of the Fourth Amendment. We then go to the requirement for a warrant. That takes all of about a week. And then we get into the various exceptions, the special rules for arrest, the special rules for automobiles, the special rules for searches on less than probable cause, the so-called stop and frisk. Then we talk about what constitutes a seizure and what constitutes a search. Again, I think the students should know the rules of what they are before they learn what they are, because I think that helps them learn better. Then the latter part of the investigatory book is on confessions and other due process issues. And the very end of the book, which candidly I don't usually get to because I teach a 3-hour course in investigation, are the various relevant factors for the adjudication course, which includes right to counsel, right to jury trial, right to discovery, double jeopardy, etc. I follow the format set out in the teacher's manual. You'll notice it is set out by class. I have 42 hours. I teach class 1 through 42, which is all of the investigatory material. One of the places where I think do maybe my best job is in conjunction with the exclusionary rule, and particularly with Map v. Ohio. I ask students questions of why shouldn't the exclusionary rule be there automatically, which frankly is something I thought when I was a student initially. I didn't understand why you didn't exclude evidence automatically. And I'm able to teach the students the difference between the Fourth Amendment as a substantive right with an add-on exclusionary procedural remedy, as opposed to, say, the confession cases where the right itself is the right to have evidence excluded. So that's just one illustration. But the main thing is that the students are thinking about these questions when they come into class. They're required to have read the material. They're required to have read the questions. Personally, I give them extra credit if they're prepared most of the time, and they tell me that in advance. And that does help in terms of class dialogue. And I think that's something that does work very well. I've found the book works really well. I appreciate all the help that Lexis has been in getting the various editions ready. If you have any questions, please feel free to contact me. I'd be most happy to talk with you about it. And take a look at the book. I think you'll enjoy it.